bill's in your packets. Just to jog everybody's memory, this bill will have an important impact on distinguishing between petty theft and organized crime. It is a tool for prosecutors and law enforcement, and we hope it will impact the organized theft that is going on at retailers of all sizes in our own backyards. Before we vote, Senator Limmer, did you want to make any comments?
Thank you, Mr. Chairman. Senate Bill 3487 creates a new crime of organized retail theft. Just as a reminder, I just have a few quick messages. 34 states have definitions of organized retail crime, and the definitions give those who are dealing with organized retail crime activities modern tools to address the changing way organized retail crime is being done today. There are a few parts to the bill. It defines organized retail crime. It establishes different penalties for organized retail crime. The trespass language is similar to a bill Senator Latz had a few years ago that we've incorporated into this bill. The bill allows financial institutions to release limited identity theft victim information to law enforcement. This bill will have an important impact on distinguishing between petty common theft and organized crime. It is intended to be a tool for prosecutors and law enforcement, and it has the backing of the Minnesota Retailers Association and the Minnesota Organized Retail Crime Association as well. We had a full hearing on this, as you had said a week ago. There was a question of a civil law definition, but this bill is intended, if passed, to be moved to the Civil Law Committee for that attention. So we have the bill in front of us.
Thank you, Senator Limmer. Any questions, comments? All right. Senator Limmer moves Senate File 3487 to pass and be re-referred to Civil Law Committee.
So moved, Mr. Chairman.
All those in favor say aye.
Aye.
All opposed? Motion passes.
Thank you. Thank you, members. All this electronic doodads we have up here is just always difficult to handle. We'll now move to the second member motion on our agenda, Senate File 3478, Senator Newman. Welcome to the committee again, Senator Newman.
Happy to be back, Mr. Chairman and members.
Please proceed.
Thank you. First of all, Mr. Chairman, I do have an author's amendment, the A1.
Is this original jurisdiction? Is the author's amendment? The committee is the original jurisdiction. This is considered an author's amendment. All those in favor, Senator Ingebrigtsen moves the A1 amendment. Hearing no discussion, all those in favor say aye.
Aye.
Opposed? The amendment is adopted. Senator Newman.
Thank you, Mr. Chairman. Senate File 3478, as amended, first of all, I would indicate that in Section 1 is language that is very, very similar to existing law found at Minnesota Statute 201.275. And then the new part of this bill involves the report that is found at the, I believe it's subdivision 3, I'm not sure, it may have changed. But there's a report that is being required in this bill that the county attorney list, or maintain a list of all cases in which prosecution has not occurred. And the two reasons for the report would be, first of all, it's an issue of transparency. This is information that I think that the voters are entitled to have regarding the performance of the elected official that is the county attorney. And the other thing would be perhaps with this transparency. In some instances, county attorneys would be more likely to prosecute claims, prosecute cases. And what I really have in mind is to simply shine a light on what is going on within the county attorney office of any particular county. Members, I have assembled for you a number of documents that are in your panel, or in your packet. And I'm simply trying to have for you in one location some recent articles regarding the whole purpose of this bill and others that I have recently been in the committee on. My constituents, I hear from on a very regular basis, and they're very, very concerned about the rise in crime, the escalating crime. And I acknowledge that I live in rural Minnesota, but they are paying attention to what is going on in Minnesota. And I don't think it is just the urban area. There is crime that is rising all over the state of Minnesota. And I believe that public safety is one of the core functions of government. And our constituents have a right to know that they are safe when they are out in their communities. And right now, Mr. Chairman, they are not feeling safe. And I hear from folks who, and I'm sure you do too, we hear from folks who go to the mall or go shopping or, you know, wherever their travels might take them. They're really afraid of carjackings and the escalating crime. So if nothing else, I think that this bill shines a light on where prosecutions are currently and gives us and this committee an opportunity to talk about it once again, because it really is an important question. And I think that the legislature has every right in the world to weigh in on the issue of prosecutions or the lack of them by county attorneys. The legislature created the county attorney system. The legislature has the right to and has enacted all sorts of laws that makes certain conduct illegal. And the objection that I have and that my constituents are having is that in some cases, county attorneys seem to be refusing to prosecute entire classes of crimes. The one that is most obvious that comes to my mind is the Ramsey County attorney has decided when the police make a lawful stop for a traffic violation, even if they find and it leads to evidence of a felony, he's not going to prosecute. And that tells me that, at least in that case, that county attorney is refusing to prosecute an entire class of crimes, as opposed to a situation where perhaps a witness has recanted, whoever it is, the victim has become uncooperative, maybe the evidence isn't present. There's all kinds of reasons why a county attorney would legitimately not move forward with a case. But the wholesale decision not to prosecute and hold those who have committed crimes accountable is not good for my constituents. I don't think it's good for Minnesota in general. I want to bring to your attention a letter. This is in your packet, but I'm not going to, you can read what's in the packet as well as I can. But there's one thing that I want to bring to your attention, and that's a letter dated January 5th, 2002 to Mr. Freeman from the Hennepin County Chiefs of Police. And on the second page, they have outlined 5 concerns that the police have raised in Hennepin County regarding prosecution of cases. They are requesting aggressive prosecution of cases. They are requesting bail reform that needs to be revisited. They want to stop the use of sign and release warrants. They want juvenile detention center admission criteria to be reevaluated. And they want or to respect the work of law enforcement officers while helping to implement the necessary reforms. Just indicative, Mr. Chairman and members, of sort of the disconnect between law enforcement and the judicial system, the county attorneys and the judges in general. There's a disconnect there, and I sincerely believe that the legislature is the proper place to address this. And if the county attorneys feel that there is a need for reform, rather than refusing to prosecute and enforce laws, they should come back to the legislature and seek amendments or repeal or legislative action, rather than branding a particular type of activity as a pretext or a pretense, and then say, I'm not going to enforce that. The only other thing that I would mention in closing is there are, I was just kind of thinking about, what could we as a legislature do to maybe help represent the wishes of our constituents. These are some ideas that they're not in the bill, but I just want to bring them to your attention so that you could maybe think about them. A writ of mandamus. I think the legislature could create a separate cause of action which would allow a citizen to bring a writ of mandamus asking a judge to order a county attorney to take certain action. I think that the first line of defense that would be thrown up by the county attorney is probably separation of powers. But until you act and a lawsuit is brought, you don't really have an answer to that question. So I do think that the legislature could enact that particular cause of action for a private citizen. I've thought about the recall statute on county attorneys, county officials in general. We could revisit that recall statute. Very easy to start a recall practice against a state elected official. It takes 25 signatures on a petition. But on a county official, it takes 25% of the folks who voted in the last election. Very, very significant and stiff barrier. So we could consider amending the recall statute for county attorneys. And you could do the same for judges. And the other thing I was thinking is that the Attorney General is, I suppose you could call him the chief law enforcement officer in the state of Minnesota. I don't think the legislature would have the authority to order him to do anything. But I think the legislature could pass a law that strongly suggests and authorizes, specifically authorizes, the Attorney General where certain cases are not being prosecuted, that the Attorney General can step in and take over those kinds of cases. Those are my thoughts, Mr. Chairman and members. I would like to see reform. I would like to see cooperation between the legislature, the county attorneys, the judges. But I honestly am very uncomfortable with some of the things that I have seen in the last couple of years within the criminal justice system. And some of the actions by county attorneys are simply part of the puzzle that I dearly hope that this committee will think about and talk about and see if we can come to a conclusion. Thank you, Mr. Chairman.
Thank you, Senator Newman. We'll move into hearing from testifiers that have an opinion regarding this bill. On my list, I only have one individual, Mr. Mike Freeman, Hennepin County Attorney. Mr. Freeman, I might want to address you as Senator Freeman. You served a little time here.
Mr. Chairman and members, thank you very much. I'm honored to return to room 15. 39 years ago, I appeared in this room as a brand-new senator presenting my first bill. Mr. Chairman, Senator Speer, then chairman, and others greeted me warmly and then proceeded to ask me many questions. It's the part of the deliberative process that this committee in particular and the Minnesota Senate is proud of. And I welcome that. But one of the things that the Senate Judiciary Committee always is well known for is thoughtful and intelligent discourse. We avoided political conversations. We focused on what was right and just for the people of Minnesota. I appreciate that tradition, and I'm glad to hear that this committee is continuing to do that. It's with that spirit that I appear with you to discuss this bill, and Senator Limmer, if you don't mind, I'm going to address a few comments on your bill as well, so I don't have to repeat myself, because I am also testifying in opposition to that. It's the practice of all county attorneys to prosecute all, and I underline all cases, where there is sufficient admissible evidence to prove the elements of the offense alleged. We deviate only when manifest injustice would result if we proceeded with the prosecution. That is our standard, and it's a standard similar found in the American Bar Association and in other ethical journals. Prosecutorial discretion is a hallowed and necessary tradition and practice in American criminal jurisprudence. It allows our offices to innovate and especially dedicated limited resources to some of the worst of our problems. Examples of our discretion can be followed in the following circumstances, among others. For example, in my office, we spend a great deal of time on our sexual assault initiative. We have implanted prosecutors in the Minneapolis Police Department and made similar prosecutors available to a number of the Hennepin County chiefs that are behind us to work on these very difficult cases. They are hard to prove. The circumstances are very awkward in the bringing of the prosecution, but we think sexual injustice and abuse has got to be stopped. And so we have allocated lots of resources there. That is a discretion that is provided to me by statute and by the Hennepin County Board of Commissioners, who county attorneys are solely funded, with the exception of some small grants, by county property tax dollars. Our carjacking initiative. I helped to establish Minnesota HEALS 2.0, focusing on violent juvenile crime, bringing together the faith community, the business community, government, law enforcement. Several members are sitting behind you from the chief's organization to respond to figure out what is exactly happening in the juvenile justice system and how does it need to be changed. And how do we handle these violent crimes, because they impact all of us, including my friends and my neighbors. Or we've used the prosecutorial discretion on juvenile diversion. My guess is there are very few among us that didn't do something stupid when they were a kid. Little Mikey Freeman certainly did, just like little Timmy Dolan, the former chief of Minneapolis Police, did. I was lucky. Minneapolis' finest picked me up and took me to the station and called my father. I wish they had sent me to Red Wing for a month instead. When Orville Freeman, then governor of Minnesota, had to pick up little Mikey Freeman, I paid the big price when I got home. But I was lucky. I had a dad that cared, and police officers understood that I had done something stupid because I was a kid. And my juvenile record was not marred, and trust me, I never committed a similar offense in my life. It taught me. Diversion of youth in their first case is an appropriate use of juvenile in prosecutorial discretion, which we must have. Now, all these initiatives and efforts often take more time and more energy than simply charging someone and taking it to court. There are also examples when the legislature has decided to tinker with prosecutorial discretion, which have met with unjust results. A classic example is in the election laws. It used to be legislators required county attorneys to charge each and every alleged election law violation. Well, in 2012, an 86-year-old woman with dementia accidentally voted twice. The voter fraud statute threatened the county attorney with prosecution and loss of position if they did not charge the case. The case was charged. Valuable resources were wasted on prosecuting this elderly woman. The case was so egregious that you all changed the law profoundly later. Thank you very much. But that's an example where if we had the discretion we should have, and we do have under present law and practice, we never would have charged that person in the first place. Or, let me take another one, global plea resolutions. An individual has been on a crime spree and finally caught and has committed 4 or 5 serious felonies, including a homicide. Well, we're going to, if we can, prosecute the homicide and give that person a long sentence. And it's really not necessary in some cases to use scarce public resources to prosecute the individual for the other crimes. Now, the victims of that crime may not appreciate that, but we are trying to make sure that that person is taken off the street for the appropriate period of time with the least expenditure of public resources. That's our discretion. And I think that's another example where discretion is well taken. Now, I understand that there's increased interest in how our office operates. In terms of having additional transparency, I decided that no longer would I take police shooting cases resulting in the death of a civilian to the grand juries. I did that because in the grand jury process, it is secret. No one knows what evidence is presented there, and no one knows who the grand jurors are. That's the tradition behind the grand jury, and there's good reason for it. But under Minnesota law, each county attorney has the discretion to decide which cases go to grand juries. Some of my sisters and brothers agreed with me and do not take police shooting cases resulting in the death of a civilian to the grand juries. Some do and some don't. But that's why I did that, and I had the discretion to do that. And I think that was the right thing to do. But I'm here today on behalf of my fellow elected county attorneys to respectfully, in all due respect, Mr. Chairman, Senator, we don't think these bills, or even a task force to look at this, are really necessary? After all, we stand for election, just like you do. And there is a history of county attorneys being unelected or not elected again, or not reelected, I guess is the proper phrase, because of some of the things they did when they were county attorneys. We also, as Senator Newman has said, there is a recall petition, and as someone who's had a recall petition brought against him for not charging as quickly or as aggressively as other people wanted, I understand how that feels. Trust me, a recall petition gets all of our attention, whether it requires 25 votes or 120,000 in my case. Reviewing the bills I was asked to testify on, Senator Newman, Senate File 3478, I don't mean to be personal, Senator, excuse me, basically calls for, if probable cause exists, we must prosecute. Well, who decides probable cause? That is the job of the county attorney. And if we overcharge a case, people can seek to dismiss for lack of probable cause before a court. I'm proud to say of those motions brought in Hennepin County, we prevailed on over 95% of those. Frankly, we shouldn't charge any case that doesn't have sufficient admissible evidence to prove at trial beyond a reasonable doubt that the person committed the crime. That is my standard, and I think that's the proper and right standard. So we do that. So who establishes probable cause? We do, or judges do. Under Senator Newman's bill, we'd have to prosecute every case of those. And if we refuse, well, thankfully, the A1 draft that is before you took out the criminal prosecution for assistant county attorneys or county attorneys who didn't do that, which is unconstitutional. But now they can be suspended without pay. And we need to report all those cases, and to, I believe it's the sentence, we have to report all those cases, okay? Hennepin County Attorney's Office last year reviewed and charged 10,000 adult felonies and over 5,000 juvenile cases. Reporting all that would be a huge waste of scarce resources. In Senate File 2841, it suggests that if we charge a felony and dismiss any part of that, we might set forth certain information and give our reasons why, and report to the Sentencing Guidelines Commission and put it on our own website. We charge a lot of cases. Why do we dismiss cases? Well, the evidence goes south. The victim, the victim doesn't want us to proceed. The evidence doesn't support the case. We have victims not showing up or witnesses not showing up the day of trial. Justice requires us to dismiss a case for which we believe there's insufficient evidence to prove beyond a reasonable doubt at the time. We need to do that. There would be hundreds and hundreds and hundreds of cases we would need to report on. In all due respect, I think each of these bills appear to be an answer in search of a problem and would require a good deal of paperwork for little benefit. All of my sisters and brother county attorneys are busy trying to do the best we can with limited resources. Our police officers are limited in number and have limited resources as well. No one expected this kind of crime wave, and it is not unique to Minnesota. It is occurring everywhere in the country. But we need to use our resources well, and that's within the discretion of the office for which we are duly elected to. I welcome each and every one of you to contact your county attorney. Come see us. Let us explain to you what we do. Let us show you the declines we've made. If you want to know the cases, and after we make a decision not to charge a case, the evidence becomes public record. We'll show you why we didn't. Why do we not charge many of the cases that come to us? And why do we dismiss others? Because we don't have sufficient admissible evidence to prove it beyond a reasonable doubt. That is not the fault of our law enforcement friends. They have limited resources, and guess what? Sometimes we can't figure out who the person is. Minneapolis Police Department estimated there were 650 carjackings in Minneapolis last year. They sent us 115, and we charged 85% of those. Why did we not charge more? because the identification of who actually stole that car and part of a violent car theft could not be determined. Okay, and the other ones that were never presented to us, the same reason. Why? So often this is a youth jumping out of the bushes wearing a hoodie and a mask, and you can't tell who it is. And if you can't identify the person, you don't have a person to charge with the crime. Again, I am not criticizing our police officers. I'm telling you the facts of life in those kinds of crimes. Now, when we get those, we move aggressively on them. One last comment. I understand, particularly on Senator Limmer's bill, that some, and I would emphasize some, law enforcement officials are here supporting that. Perhaps law enforcement, if we are required to report, law enforcement should be required to report as well. If we need to report each case that we have probable cause that we don't go forward with, well, then the police ought to report each case that they don't submit to us because there's lack of probable cause. Or if we dismiss a case, well, we have to file that. I think the police have to. What I'm trying to point out in all due respect is we should be held accountable for what we do, and we are. We are at the election box, and we are with the voters we talk to. Now, I'm sorry that the concerns expressed by at least one chief and one former chief about the actions of the Hennepin County Attorney's Office dated January 5th is before you. I have met with them a number of times and answered a number of the questions. Frankly, there's little merit in what's set forth there. I'm not here to debate each issue. It is best in the law enforcement world and the criminal justice world for us to work closely together. Since being issued that ultimatum, I have been to 4 Hennepin County Chiefs meetings. I've met individually with some of the individuals behind me. I've had numerous conversations with chiefs. We've always done that before. That has been my practice since I was first elected county attorney in the election of 1990. Some of the communications broke down over the pandemic. We understand that. It was harder to get together. And I don't know, most of us who stand for election do better when we can look people in the eye and we can talk and share our honest thoughts. Mr. Chairman, that's what I'm trying to do today. I appreciate the deliberations that take place in this room and on your committee. And unusual for an elected official and a lawyer, I conclude my arguments.
Thank you, Mr. Freeman. I wanted to make one announcement. With the rest of the bills, including this one, on our agenda, we will be laying these bills over for further discussion. However, that's the end of our testifiers, and we will open it up for discussion. Oh, Mr. Small. Welcome to the committee. Would you identify yourself for the record and then proceed?
Thank you very much, Mr. Chair, members of the committee. My name is Robert Small, and I am the Executive Director of the Minnesota County Attorneys Association. I don't have much more to say than what Mr. Freeman said, but what I did want to do is cover some of the specifics in the bill. I appreciate the wisdom of the amendment, which took out the criminal penalties as it relates to our county attorneys and the removal of office for our county attorneys, but much to the chagrin of the 800-plus assistant county attorneys who now face some kind of sanction for not bringing a charge. I would really ask you to review that. This bill, the language of this bill, as Senator Newman pointed out, mirrors the voting rights bill or the voting statute. Let me tell you what that statute says. That statute says that the county attorney shall proceed according to the generally applicable standards regarding the prosecutorial functions and duties of a county attorney. Members, that means that county attorneys exercise prosecutorial discretion. That's what that phrase means. And if that's what that phrase means, then why do you need Section 1 of this bill? To potentially punish our 800-plus assistant county attorneys for trying to do their job as best as they can? I'm not sure that that's what this committee wants to see happen. Let me talk about Section 2. Section 2 of the bill, as I just mentioned, was significantly changed with the amendment. And again, we appreciate that. But look at that. 800-plus assistant county attorneys who come to work every day and try to do their job. That's what you're doing. You're putting them in the crosshairs. Let me talk about Section 3, the reporting requirement. Do we really want to make public? Do we really want to make public that a particular defendant started cooperating with police and is now an informant? Do we really want to do that? Do we really want to make public that the victim stopped cooperating and does not want the case to go forward? Do we really want to make that public? Do we really want to make public that a particular the reason that the case wasn't charged because the law enforcement officer was found to have lied on a prior case? Is that what we want to make public? Do we want to make public other reasons for not charging a case? The victim changed their story. The victim lied. Is that what we really want to do, is make that information public? I don't think so. I don't think so. And so those are the concerns of all our county attorneys and the reason we oppose this bill. I'll stand for questions long, Mr. Freeman.
Thank you, Mr. Short. I don't believe there's any other testifiers before this bill. We'll open it up for committee discussion. Senator Bingham?
Thank you, Mr. Chair. And thank you for Hennepin County Attorney Freeman for your testimony and Mr. Small for your testimony. I just want to reiterate something that Mr. Small just said, which was about the assistant county attorneys. One, they're members of a union as well, and I think that could interfere with the collective bargaining side of things, kind of go above and beyond that and around that. I think that could be problematic. I also am wondering how, if Mr. Small is available, that this would impact retention, recruitment of prosecutors. And subject to that is, do you know if applications for assistant county attorneys or attorneys in general, if you will, to county attorney offices are down?
Mr. Small.
Mr. Chair, Senator Bingham, thank you for the question. One of the things that Senator Newman handed out, and I would call your attention to it, it's an article about 2 county attorneys leaving. And the reporter got it a little bit wrong, but let me just share, because I'm quoted in that. And I was quoted about assistant county attorneys leaving, and the implication was they were leaving for the same reason that the 2 particular county attorneys. That's not what I said. What I said is that we are facing nationally a huge number of vacancies and turnover in assistant county attorneys' roles. And so, Senator Bingham, I hope that's responsive to your question, because there's a whole bunch of information in there. I belong to a national organization, then it's nationwide, similar to the shortage of police officer applicants. We are having the same issues.
Mr. Chair,
Senator Bingham?
Thank you, Mr. Chair. And that's kind of my point, because I think if this is an issue that would not help increase the prosecutions, that's not going to make our communities any safer. And I think when we look at collectively community safety and public safety as a whole, it's a team effort, and that requires really good communication. But if we're down police officers and investigators, which we have a lot of bills here, and I hope they make it through to put money towards that. Right now, you have investigative cops that have to go back on the street because we're down officers. And therefore, that becomes an issue with being able to, to charge the cases quickly and all of that. And so I think it's, as you're saying, it's a system-wide national issue. And so I just think that subdivision 2 is problematic for that reason, as well as it's just for retention and recruitment of prosecutors. So, thank you.
Senator Latz?
Thank you, Mr. Chairman. Mr. Small, I do have a question for you. Don't go too far.
Senator Lance.
Thank you. Judge Small, you've seen these issues from a lot of different perspectives over the years. But now you're here on behalf of the Association of all the county attorneys in Minnesota. So I'm sure you're familiar with the fact that county attorneys don't only prosecute felonies, although in Hennepin County, that's probably the largest share of their work, because most municipalities have their own either in-house criminal prosecutors or they contract with private criminal prosecutors to handle many of the misdemeanors and gross misdemeanors. I believe Ramsey County is similar in some respects, certainly outside of, well, St. Paul has their own city attorney's office that does their prosecution, so does Minneapolis for that matter. My understanding is in most of greater Minnesota, county attorneys tend to prosecute all the criminal cases that arise in that county. Do I understand that correctly?
Judge Small?
Mr. Chair, Senator Latz, your understanding is correct. There are a number, for example, Carver County. Carver County is the city prosecutor for all cities in Carver County. Faribault County is also the city prosecutor. The county attorney is the city prosecutor. There are a number of those. Sandy County has a number of city attorney contracts where they prosecute the city attorney work. So I can't tell you specifically, Senator, but you are correct that there are many of our greater Minnesota county attorneys who also do city attorney work.
Senator
And
Latz?
Mr. Small, in your reading of the bill here, this would apply to all levels of cases, right? Or is it just, maybe I'm asking the wrong question because I'm reading the bill here. It does say for a felony offense.
It does.
Okay, so this would only apply to felony offenses?
That's my understanding, Senator.
Okay. And what discretion then would this give, if anything, to a county attorney that charged something out as a felony offense, but felt that in the course of plea negotiations, a gross misdemeanor or misdemeanor level of conviction would be more appropriate, or a stay of adjudication might be more appropriate? At what point does the charging requirement or the requirement to prosecute become more discretionary again, if this is read as a mandatory statute?
Judge Short?
Mr. Chair, Senator Latz, that's an excellent question, and it would seem to me that the bill talks about charging decisions, and that is kind of an unknown. You know, there's another bill that deals with dismissals, and so I think this bill just focuses on charging decisions. Another bill that we might be talking about deals with dismissals.
Senator Latz?
Mr. Chairman, Mr. Small, one reason I asked that is because as I read the bill, It says, "The county attorney shall proceed according to the generally applicable standards regarding the prosecutorial functions." So I read that the way you do, which is that this creates a discretionary standard, so it really doesn't change much. But if the intent is to make it mandatory, it's unclear what prosecution required means. I mean, does that mean prosecution all the way through a trial on the original charge of a felony? Does that mean there's no discretion to agree to a Chapter 152-18 stay of adjudication on first-time low-level drug offenses? Does that mean, there are a dozen different ways to resolve cases that start out as felonies. Sometimes it involves the dismissal of a top count and a plea to a lower count, which may not be a felony. Does that mean they have to prosecute all the way through trial on the felony count? I think that's open. The way language is written, I think that's an open question. Because it doesn't say only shall charge, unless I'm missing that language in here somewhere. I'd be happy to be corrected on that if I'm misreading the bill. But I want to ask you another question, because you've seen a lot of this stuff, and we've all been part of the last several years especially, of some really tough, emotional cases where members of the public, particularly in certain communities, have been very vocal in their public approaches to what ought to happen with cases. And sometimes there are strong, emotional, public demands to prosecute cases, to charge cases or prosecute cases within moments of the incident that leads to the decision that needs to be made. The allegation that a crime occurs. Someone gets assaulted, whether it's by a police officer or whether it's by someone else on the street. And within moments, you've got crowds demanding justice, and for them, that demand may mean prosecute to the full extent of the law. In fact, there was one case in Hennepin County where you had exactly that kind of circumstance, and it was all over the news, and it went on for days. But when ultimately the charging decision was made, the public evidence was that there were half a dozen different views from eyewitnesses as to what actually happened. I guess my point is, sometimes people, often for justifiable reasons, but as a lawyer, I try to step back a little bit, reach conclusions about what happened before the evidence is even available or analyzed, let alone made public. And I'm concerned that a bill like this, if it's read as a mandatory charging bill, could result in county attorneys or assistant county attorneys bringing charges because of public pressure or because of fear that they're going to face some other kind of consequence, suspension without pay or dismissal, or because of the future electoral prospects, rather than based on their constitutional duty to evaluate the evidence and determine if they can prove beyond a reasonable doubt to the satisfaction of a unanimous jury that the person who was charged actually committed the crime. And I hate to have to go back to the Constitution on this, but I'd like decisions about potentially charging a person with a felony crime and maybe putting them into prison for years is based upon the Constitution and the evidence, and not based upon other factors. Whether that's pressure from our law enforcement folks, or it's pressure from community groups, or whether it's pressure from the legislature. I want the person making the charging decision to look at the evidence and the Constitution and the standards of proof, and that's it. And we bring a bill like this, we pass a bill like this, that's going to change all of those incentives. And this has nothing to do with is a person guilty or innocent. This has to do with the use of the awesome power of the state to physically imprison a person. That's a pretty important power, and the founders of this country put in several of the amendments to our Constitution and our Bill of Rights to protect individuals against the abusive exercise of just that power. This bill is intended to, and would in fact, in my judgment, tip the scales of that constitutional duty. My recollection is that, and maybe this really isn't for you now, Judge Small, but my recollection is that part of the motivation here, as was testified to, has to do with the Ramsey County Attorney's decision to decline to prosecute a class of crimes. But what was not shared here, and believe me, correct me if I misunderstood this, but my understanding is not that the Ramsey County Attorney decided not to prosecute a whole class of crimes. But the decision was to not prosecute those crimes that were found out about, if you will, because of stops of motor vehicles that were based upon certain kinds of behavior or circumstances that are very often used or allegedly used as pretext to stop certain kinds of people. Now, I'm gonna get in trouble probably for saying some of this, but there are plenty of communities out there that feel that they have been harassed because of the color of their skin. And I don't cast aspersions on our law enforcement folks as a whole. I don't. I've got a ton of respect for the work that they do, and I firmly believe that almost every one of them does it to the best of their ability and does it without bias and without favor. But not all of them are that way. And certainly some communities feel like not all of them are that way. And if the fact that a young black man gets stopped 40 or 50 times for speeding in a community when certain a young white man in that same community hasn't been stopped that often. And I don't think anyone can dispute some of those facts. Tells me that there are plenty of cases where people are being stopped because the hope is that we'll find something else on them, that they'll have contraband in the car, that there'll be a warrant out for the arrest. In fact, we've had testimony here in this very committee that backs up exactly that. In fact, there was testimony in this committee that said,
Sarah Lance,
we
could
get
we
a certain
stay on the bill?
percentage.
Could we stay on the bill? Sarah
Well, we
Lance?
are, Mr. Chairman.
We have a number of other senators that would like to talk in the allotted time that we were given for the committee.
No.
And you're moving into a half an hour now. And we're laying the bill over. There'll be plenty of time for further discussion later on as well.
Well, maybe I should ask Mr. Chairman, because sometimes bills get laid over and then they show up as a part of a 50-page omnibus bill, and we have an hour and a half to review and discuss every component in that.
Yep.
So is it the chairman's intent to bring this bill back as a standalone for us to have further discussion about, or is it gonna show up in a big omnibus bill?
We have
no
not made
time?
that decision yet. Sarah Lance.
Well, then, Mr. Chairman, it seems to me this is really my best opportunity to,
Well,
but I respect what you're trying to do. There are other people that want to have some conversations here. But my point is, I guess, Mr. Chairman, this bill does not give the prosecutors the opportunity even to respect the preferences of the victims in a case, who may not be recanting, who may be willing to cooperate, but who really don't want the case to move forward. And the prosecution would not have the ability under this bill to decline to charge a case like that. There are a lot of reasons why we have prosecutorial discretion. To the extent that this removes it, I think this will lead to travesties of justice. Thank you, Mr. Chairman.
Thank you, Senator Lance. Senator Matthews.
Thank you, Mr. Chair. I have a question probably for Mr. Freeman, and maybe Mr. Small would want to give his opinion on this too. I appreciate the discussion that we've had. I definitely have a lot of respect for your years of service, both at the legislature and in the county attorney's role. And so let me set up some of my thoughts and ask for your feedback to clarify if this was your position you're sharing today. I was a little surprised that you characterized these bills as solutions that are searching for problems. And I took it at first as to wondering if you are denying the fact that there's any type of underlying problem whatsoever. I wondered if your testimony came as saying, I don't know that these are the correct solutions that we should be applying. I could understand that, and this committee could work out, is this exactly what we want these bills to say? Are these, new policies, should we change them in some way? But you came saying these look like they're solutions in search of a problem. And you laid out a number of discussions of the actions your office is doing and a number of comments made by my colleagues here of different roles and different ways that decisions have to be made, that choices on charging or not charging in a variety of circumstances. And those are all fine and well, like your sexual assault initiative that you mentioned. I bet you poll your community, you'd get about near close to 100% support for things like that. That's not the reason why we have bills like this here before us today. Things about respecting, if a victim changes their mind or if there's a sensitive topic on a particular situation like that, that's not the reason why we're here today. We're here because there's an increasing number of cases I'm seeing on an almost daily basis now of cases that have come up where someone was a decision was in either on your office's hands or a similar office in another jurisdiction, and a decision was made not to prosecute, and shortly thereafter they're back out and committing more crimes on other victims out in the communities. And these bills are an effort at trying to get why I'm trying to understand, even from my perspective, why we're in this type of position from those tasked with charging these types of cases. But I wonder if you'd expound on that and clarify if you're denying any sort of problem whatsoever, if you see the problem differently, if you could help us guide to what a solution might be. And we probably all agree on reasons that were given that seem more excuses, is that we'd all agree they should be made in these cases, but help me get at the root of the problem as to why we are likely here with this issue today.
County Attorney Freeman.
Mr. Chairman, Senator Matthews, as I stated in my beginning comments, this committee speaks with wisdom, and you are correct. If you thought I was denying that there's no issue in the question of crime in Minnesota, I was not. And I apologize if that's the impression I left you. Is there a problem with serious crime in the state of Minnesota? Yes, there is. Is there problems with insufficient number of police officers bringing cases to us? Yes, there is. Is there a problem with that workload for presenting cases to us that do not have sufficient admissible evidence to charge? Yes, there are. Police arrest and investigate. Prosecutors charge and prosecute. They're different functions. We work best together in the criminal justice system if all parts of the system work together. That includes the police and the prosecutors and the public defenders and the judges. We need to all work together, and frankly, we're all understaffed. And judges make decisions that I disagree with. But they're not called before the legislature to explain each and every decision they make. I've been criticized by some folks of selecting some non-violent crimes to be taken off the list for which we ask for bail, we prosecutors. Well, first off, we don't decide the amount of bail or whether bail's done. That's done by judges. We make a recommendation. and a person charged for illegal or improper collection of welfare checks, what we call WOPA cases, in my view, doesn't have to be held in jail for weeks and weeks before the trial comes. That's one of the cases that I did. Now, trying to be responsive to folks, the people behind me suggested that we ought to ask for bail for auto theft cases. Let me tell you the difference between an auto theft and a carjacking. An auto theft is when someone leaves their car running and runs into a convenience store to get a jug of milk. Perhaps unwise. And the car shouldn't be stolen anyway, but it's not violent. That's totally different than somebody jumping out of the bushes, pistol whipping someone, and stealing the car. I asked for bail in those cases, and the testimony before our HEALS 2.0 committee last week showed that virtually all of those juveniles are held awaiting the first court appearance. Virtually all of them. And that's not what some of the chiefs in Hennepin County have been saying. They were wrong, and I showed them they were. Secondly, are they held until they're adjudicated? Most of them are. That again came out at the HEALS presentation, because you all and the public deserves to have the real facts, not ones that fit someone's theory of what's going on. So, is there a problem? Yeah. Are we working on it? I just don't think asking us to report on each case, but if it was probable cause, why didn't we charge it? Or each case, why we had to dismiss something. You know, part of the system, Senator, is plea negotiations. The system wouldn't work without it because of the number of cases. And those are situations where skilled prosecutors and skilled defense attorneys look at the value of a case and decide what appears to be fair and just. And it has to be approved by the court. That's the fail-safe one. But we do that together. And part of that is dismissing things. So I could see if this bill became law and we had to report on probable cause. First, why don't we have probable cause in most cases? Overwhelmingly, there is sufficient evidence. Who brings us the evidence? Law enforcement. Does that mean they're not doing their job? No, we just don't get it because it's not there. They haven't been able to find it. I don't think that helps the process of bringing more public safety. Or we dismiss something in an appropriate plea negotiation. That's how the system works. Members of the legislature, passed while I was here was a bill brought by Representative Steve Wenzel from Little Falls to have us report on every 60911, which is gun bills, and whether the mandatory minimum sentence was brought. And ever since that, every county attorney's office has to perform that. And it takes a great deal of time in a county such as mine, where there are a lot of those gun cases. Now, it's been very clear from the beginning, I'm very aggressive about gun prosecutions. They've done that, and those numbers reflect that. But sometimes the gun evidence disappears and we have to dismiss that under the cause of justice. Sometimes the judges have less than a mandatory minimum sentence. And all that has been reported, and I've never seen the legislature do anything from that since 1993. No, it was before that. Anyway, I can't remember the exact year. We don't need more reports, task forces to require our time and energy to do that. I'm open in my books. You all come over and I'll show you what I do when I do it, okay? And these chiefs I've talked with endlessly about their cases. And we've done that because we should do that. But it's just, in all due respect to the authors of these bills, I don't think this is the best way to do it. So again, let me apologize. Don't disagree that there are challenges in the criminal justice system. But they're joint problems. And we ought to collectively work on solving those and not create a massive amount of new paperwork for which I think there will be little benefit.
Senator Matthews?
No, Mr. Chair, I'll let others go in the interest of time, but I appreciate that. Thank you.
Senator Ingebrigtsen?
Thank you, Mr. Chair. And I'm sitting here listening to this and looking at some of the reports here, and frankly, in 35 or 34 years of law enforcement, I worked with county attorneys all the time, and I'm quite saddened that we would have to bring something like this forward, actually. But I'll tell you why I support Senate File Number 3478, at least in its form. If it needs some tweaking here and there, again, Chair Limmer, you said we would do that before it becomes potentially law. But when I sit and watch what goes on, and what the community has watched, what goes on, there's no wonder why we're here. County Attorney Freeman, you just talked about bail. And I've got a whole list of what your policy is here, and crimes where bail is not requested: fifth-degree sale, possession of narcotics, theft of under $35,000, theft of a motor vehicle, and I understand what a theft of a motor vehicle is versus a hijack, forgery, damage to property, I don't know what kind of damage to property that would be, mail theft, counterfeiting currency. I mean, it just goes on and on and on. I personally know of about 3 years ago, there were 47 small-time drug dealers in Minneapolis that were arrested. 46 of them were black. And those charges were dropped because 46 of them were black. Now, you can deny that or not, but I remember the headlines very clearly, and I'm sitting here thinking to myself, if I'm a drug dealer, guess where I'm gonna go? Guess where I'm gonna go? County attorneys, Senator Newman, you talk about passing new laws for recall of county attorneys, or having the Attorney General's office prosecute all major crimes. I couldn't be more against that. We all talk about local control. We know what prosecutors do locally. And the Attorney General has always been there available for those smaller counties who have major crimes that don't have the expertise or the know-how to probably prosecute. And I don't have a problem with that. But to turn a whole bunch of what has recently, by the way, 3 different county attorneys here locally have turned police shootings over to the Attorney General, as far as I'm concerned. And for whatever reason, protesting or whatever. Maybe they couldn't stand the heat, I don't know. And I know about the heat. I sat in that very first meeting, and a couple of officers in this room that were in that meeting, where we had people with signs saying, "Save a kid today by killing a cop. Kill a cop and save a kid." That was going on in one of our committee meetings, Mr. Chair. So, Columbus statue being pulled over. You know, Tony Boza came here how many years ago and said, if you don't take care of the small stuff, it's gonna turn into big. I don't think anybody will dispute that. But this was no kid that pulled over the Columbus statute. He was about 54 years old. I talked personally with County Attorney Choi. I said, how are you gonna prosecute him? Or what are you doing? He was charged with a felony. And that was stayed. He had 100 hours of community service. When he did that in front of God and everybody, the governor, God, state troopers, and everybody. And didn't deny it. He said, take me to jail. He's not a kid. What is that? What kind of a message is that sending the public? You wonder why these bills are coming forward. It's hard for me to understand. Senator Latz, the community always gets brought up. I think we're talking about the black communities. The black-on-black crime that's been going on in this metro area has been horrible, absolutely horrible. So I don't know if you can look at the cops and say, quite frankly, the cops that have done something wrong there's been justice. They're in jail because of what they've done wrong. So Senator Newman, I appreciate you bringing this bill forward. I think it's about time somebody else other than law enforcement or probation or whoever else is in the system takes the blame for all this rise in crime. I think the prosecutors who are not prosecuting, if they aren't, start having to answer for that. The cops are answering for it. The public wants something done. And then I'm gonna finish with this one piece of the article here. And I've said this since the George Floyd incident, which created a whole bunch of problems, as you all know, nationwide. But pretty soon the cops are gonna look the other way. If you have any cops, if you can find cops to fill the vacancies. And they're leaving because they don't have the support of the community. They don't have our support. I'm sorry to say that. But if they start looking the other way because there's no prosecution, is the public served? Of course they're not served. And guess what? That paycheck is gonna come the same every month for that cop. And I hate to even talk like that. I hate to even think that they would do that, to look the other way. Go over here and write a parking ticket because it's easier. Because if I go over here and stop what I know is a major crime, what I'm trained to do and trained to go to and fight against and arrest, why would I want to go over there and get put on trial myself? I'll go over here and write Senator Ingebretson a parking ticket by the fire hydrant. That's a lot easier. So my fear is that's gonna happen. It's gonna go on, and if I've insulted the guys in uniform here today, I'm sorry. To even think about that, it just drives me crazy. I'm gonna end with that, because I know Senator Johnson's got some.
Senator Kiffmeyer.
Thank you, Mr. Chair and members. Probably the hardest thing here is the respect I have for the county attorneys. And my bill later on today is going to help to bring some strength to their job situation. But the biggest thing is to remember that the police are hired to do what a private citizen should not do, taking the law into their own hands. So what the citizens do, they write the paycheck through their taxes. They write the paycheck so that you, the law enforcement, our police officers, our sheriffs, go do what a private citizen does not. They don't enforce the law. But when they are victims of a law that has been broken, then on their behalf, the police and sheriffs go ahead and catch the criminals and do those investigations. But you're doing it on behalf of the people, some of them not victims, but specifically in regards to those who have suffered as a victim from a crime. And I don't know about this. I understand that there are those where you use a weapon, but pulling somebody out of a car or taking their car, driving away with it, I don't know, that sounds pretty violent to me. And why we have to make this distinction is beyond me. I think it's pretty offensive to people that, well, it was just $35,000, so that judgment of that. But it's very important to realize the role that they play on behalf of the people who count on them to do that. And the people in the minority communities and the low income are the most harmed because they have the least resources to defend themselves. And so for them, this is critically important. And repeat offenders, again and again and again, means repeat victims again and again and again. And the system that they are trusting, that's what's happening right now. They're not trusting the system anymore. Those who they believed were there for them to act on their behalf. Why are we here in this committee with these kinds of bills? It's because of that. Because they have communicated to us again and again and saying, we have lost that confidence, we've lost that trust in those who are there that we could count on to act on our behalf so we don't take justice into our own hands. And that's what also concerns me here. When the system does not do that, then the general public starts saying, well, if you aren't, then maybe I'm going to have to step up and do something. And so that rule of law and that whole system, very fragile right now. And what we're doing here in responding through these bills is the folks in our communities who express that, not just in our particular cities, but in regards to our visits and our time spent with people in inner city Minneapolis, inner cities everywhere else, because they are most vulnerable to it. They're the ones who most need the rule of law and order and that enforcement, and to know that that will be there on their behalf, because they are the ones who suffer. So we can talk about the details of the legislation, yes, let's make it workable. Let's do those things. But don't leave the people out there defenseless in a time like this. This is the one thing that sets us apart as a civilized country, is having the rule of law and order, and that no man gets to make these, or woman gets to do these on their own. It's a system, laws that are passed, and that no other entity should be able to just set aside things without being able to be held accountable. So whether it's this bill and these exact languages, thank you, Senator Newman, thank you, Senator Limmer, we are responding to those people who want that, and they want it done well, and we are willing to listen and hear and write these things and do them so that they are fair to everybody. But to just be silent and not take an action is not an option. Thank you, Mr. Chair.
Senator Johnson.
Thank you, Mr. Chair, and I know we're short on time, so I'll be quick here. I'm just a small-town country lawyer. I don't do a whole lot of criminal work, but when I look at a bill like this and start studying a little on that, you think about the victims of these crimes and what little recourse they have if the discretion of the prosecuting attorney is such that they feel that they overuse that discretion in their particular case. And remember, the assistant attorneys, in order to prove a case against them, the victim or whoever's bringing that case would also have to have the probable cause established in order to convict an assistant attorney or whatever it is as well. So there's a high bar there too as well for, you couldn't just bring up a fictitious claim or something that would be frivolous on that as well. So they've got a real vested interest in making sure that if they do bring a claim, that it's something that can be substantiated as well. So I just want to get back to the bill briefly with subdivision 3 here. We talk a little bit about the reporting. One of the things that I'm particularly interested in is Attorney Freeman brought up that constituents can recall. But if you don't have any quantitative way of evaluating a prosecutor's performance, it becomes pretty difficult to make a substantial case against a prosecuting attorney in that case. I think one of the nice things about having that report is just a common sense way of helping out constituents know if the prosecutors are doing the job that we've hired them to do. So to me, I know there are some technical issues that have been brought up today. However, I think as far as for our communities, it's a pretty important piece in being able to hold folks accountable and have consequences and actually think about the actions that they're doing at that point. And as to a point that was brought up earlier, where the constitutionality was called out on a prosecutor who charged based on the facts, I don't follow that logic when I'm looking at this. If the facts are there and we're asking them to charge out with the probable cause, that's what we're asking to do. That's what we are here at the state legislature to do, is set forth the factors that need to be considered when they are charging out a case. And so the idea that it's unconstitutional to charge out based on the factors we lay out in the facts of the case, I don't quite follow that one. The prosecutorial discretion is something that's sacred to attorneys, and I get that. But that can be abused as well, too. Luckily, in state law, in case law, we've got a couple of cases in which they reference the ability of the legislature to have limiting language, statutory language, to limit that discretion. So it hasn't been unheard of before. There's also cases out there that talk about discretion being abused and that a writ of mandamus may be in order where that is something that's a factor. So in order to have a writ of mandamus, the discretion has been clearly arbitrary and capricious. That's something that we need to look at. That seems to follow very closely with what this bill is doing. I think it's a very common sense way of approaching some of these issues. So thank you very much for bringing this bill forward, Senator Newman. It's a great discussion today. I appreciate your time.
Thank you, Senator Johnson. We'll be laying this bill over, and we'll continue this discussion at a later date. We have a little change in our lineup. Senator Kiffmeyer, we will have to take your bill up on Monday. We ran a little long. We want to take care of Senate File 2841 and Senator Weber's bill still today. I know a lot of the discussion on this bill is appropriate for Senate File 2841, which will be at the next, that's the next order of business. I'll transfer the gavel over to you, Senator Johnson, and give my presentation.
So, Mr. Chair, we can just use the same notes that we used earlier for this bill, too? Well, Senator Limmer's making his way over there. Welcome to the committee. I see we have some uniformed officers. Thank you for coming today. It's great to have you in the audience. Senator Limmer, when you're ready, to your file.
Thank you, Mr. Chairman. Senate File 2841 is a bill that recognizes transparency in charging. It's considered the Transparency in Charging Act. The bill requires all 87 county attorneys to report summary data on charging decisions to the Sentencing Guidelines Commission, which will be included in their annual report to the legislature. The impetus of the bill really stems from questions I'm getting from my community, and I'm hearing not only my community, but statewide. Why so many incidents of violent crime are committed by repeat offenders with multiple felonies on their record and frankly should be in jail. We currently require significant data from law enforcement to be reported to the legislature, to the post board, and to the public. This request is really no different. This is a small step to require reporting of limited summary data on charging decisions, and that's to help transparency for our public. Currently, some county attorneys, much like in Hennepin County, report basic data on their website. But we do not have a statewide look at the data collected anywhere else. The bill does not touch on prosecutorial discretion, but is a step in the right direction to provide the public with more information in response to the surge of the increased crime at the hands of serious offenders who have been in jail in the past, but were able to commit additional crimes against the public. I'm joined by Police Chief Eric Werner from Maple Grove, who is here to provide more testimony. Just wait.
Yeah, thank you. You may begin.
Mr. Chair, members of the committee, thank you for having me today. My name is Eric Werner. I'm the Chief of Police for the City of Maple Grove, and I'm the current president of the Minnesota Chiefs of Police Association. I'm here speaking on behalf of our association, which represents more than 300 police chiefs across the state and 150 command staff members. I want to thank the committee for the opportunity to provide testimony in support of this important bill before you today. During the past 2 years, there has been a dramatic increase in crime across the state of Minnesota. The Minnesota Chiefs of Police Association works tirelessly with its members to proactively learn about the needs of its chiefs and ultimately the public safety challenges within their communities. Executive Director Jeff Potts and I have traveled to our regions across the entire state to participate in listening sessions and to gather survey data to develop our association's legislative priorities. One key priority we heard from our members on is the need for county attorneys to provide data to the legislature about felony-level offenses that go uncharged. Many police reforms have been enacted that have raised the concerns of law enforcement leaders and community leaders. Bail reform, expanding pre-charging alternatives, expanded use of sign and release warrants for more serious crimes, lack of charging serious crimes in some cases, has reduced the accountability for offenders and contributed to this increase in crime. Additionally, our community members are demanding answers to massive violent crime increases at the hands of serious offenders who should have been in jail but were able to commit additional crimes against the public. To illustrate our concerns, some chiefs asked that I share summary incidents about their experiences in their communities. A suspect was involved in a high-speed pursuit. Investigation proved the case. The county attorney refused to charge the case because the subject had other charges in another case, and that is good enough. Suspect fled from officers again. Suspect stalking a victim of domestic violence and taunting victim, "I got away again, you won't sleep." Chiefs are questioning, signing release warrants for persons and felony offenses while subjects reoffend. Another incident where a suspect committed a burglary, stealing a shotgun and prescription medication. The suspect committed terroristic threats towards a victim of burglary, and a search warrant recovered the shotgun in the subject's possession. Charges were pleaded down, and the sentence was 5 days sentence to serve. During a recent meeting with chiefs and other criminal justice leaders, an important question was asked. How does a carjacking suspect have 31 prior offenses when arrested on a carjacking, on a current carjacking? Another incident that happened recently, and this was in the media, and members of the committee can view the data from the dashboard cams. Just this year, in Brooklyn Park, their department responded to a case where the suspect had fired more than 40 rounds through the walls of a townhome, with one round striking a neighbor in an adjoining unit. As officers arrived on scene, the suspect drove through his closed garage door. He later intentionally rammed 2 squads in his attempt to escape. He refused to exit his disabled vehicle. Officers negotiated with him for over 30 minutes until he peacefully surrendered. A handgun was later located in his residence and in a snowbank along the path of the pursuit. All of this was captured on squad car video and body camera video. He was charged in the weapons case and for shooting his neighbor. He was not charged for fleeing the police or assaulting the officers in the cars. Both would have been felony offenses. The decision to not charge the fleeing or assault with his vehicle is alarming and troubling, not only to the officers, but also to the community. For those officers suffered concussions and put their lives on the line to stop the dangerous career criminal who is currently now out on bail. His neighbors have been forced to find alternative housing in fear that this may happen again. I talked to the chief, and he was told that the more serious offenses were charged. Fleeing and assaulting an officer to that level is a felony. That's a pretty serious charge, in our view. We have experienced refusal to charge felony-level marijuana cases in excess of 100 grams. While we understand the need for county attorneys to have prosecutorial discretion, we also believe that the unilateral changes in what laws are going to be enforced and prosecuted is a legislative matter. It's not a policy decision. Communities need to be involved in these decisions because they are the ones suffering as a result of the unintended consequences, sometimes fatally. We are all trying to do what is best for our communities. We must work together. We must do better for our citizens. Lastly, the one chief asked me to share, a suspect was arrested while driving a reported stolen vehicle, and he ignored commands on a felony stop and picked up his small daughter, carrying her away from the stopped vehicle while officers had guns out and gave commands. He held her in between himself and the officers. Charges were not pursued for child endangerment. The suspect was also charged with multiple other crimes, including violating an order of protection with another occupant in the vehicle, and had a current Hennepin County sign and release warrant for domestic violence. Members of the committee, it's important to note that our association wanted the committee to hear directly from the victims of crimes in our communities. Unfortunately, the victims that our chiefs reached out to are too afraid to speak publicly. For doing so would re-victimize the victims and further add to their trauma. Quite frankly, they expect us as criminal justice leaders to ensure the criminal justice system works for their safety and best interest. As police leaders, we are an integral part of the criminal justice system. The requirements contained in this bill will ensure critical data is collected by our county attorneys. It is one solution that will enhance our ability as criminal justice leaders to collaborate with a greater understanding of the crime and public safety problems and inform us if policy initiatives working and help guide the best solutions for our victims and citizens as a whole. I just want to add something that I was not prepared to talk about today, but I heard in the previous testimony. Collecting data is not a waste of time. Collecting data is a tremendously valuable expenditure of our time, and we have to find a way to make it work, particularly with the county attorneys. There is approximately 17,000 police agencies across our country, ranging from a couple officers to 30,000 officers in the New York City Police Department. We all are required by law to report our crime data that was once UCR, which is now the National Incident-Based Reporting System. And that is one comprehensive system that probably reports millions of crimes a year. We can get the data and we can make it work to make our system work for our victims and also for our residents. So again, I want to thank you for the opportunity to speak to the committee today. Executive Director Potts and I can stand for any questions that you may have.
Thank you, Mr. Warner. Appreciate that.
Mr.
Senator
Chairman, I'd also like to introduce Mr. Jeff Potts, the Director of the Minnesota Chiefs of Police Association.
Director Potts.
Mr. Chair, members, thanks for the opportunity to be before you today on this bill. This bill we refer to as a Transparency in Charging Act. I just want to reiterate or clarify, I guess, a couple things that Chief Werner mentioned. This bill does not aim to curtail or change or limit prosecutorial discretion. This is a data collection bill. We want to see the data so that we can view some of these decisions, what I'll call programmatic prosecutorial discretion, where certain types of crimes that have been mentioned here today are not charged, or other programmatic decisions related to charging can be looked at and really viewed through the lens of public safety, through the lens of justice, through the lens of the victim, and through the lens of, frankly, those who commit the crimes. Without this data, it's really hard to determine whether or not these programmatic changes or prosecutorial discretion are effective or not. We have learned over the last few years that, as Chief Werner has mentioned, that more data leads to better policing, better decisions, better programs as we try to implement in our communities to keep them safe. We believe that this data will help us better understand those decisions and how effective they are for our communities. As was mentioned, these decisions are important to justice, to the victims, to public safety, and frankly, those who commit the crimes. There's confusion in some areas where there are programmatic prosecutorial discretion decisions made, and for example, St. Anthony, who is a city that is partly in Ramsey County and partly in Hennepin County. There are decisions from the county attorney that are different from one side of the city to the other. That creates confusion for the police officers in that city, and obviously the state patrol, who patrols 87 counties, have to keep in mind the different decisions or prosecutor discretion kind of programs from one county to the other. That becomes confusing. We understand that diversion programs can be good, and in fact, there's statutory language that requires diversion in Hennepin and Ramsey County. We don't question the value of diversion. We know that that ultimately is a reason for a dismissal, but we'd like the data to look and see how effective that diversion is. For example, how many times should someone go to diversion before they transition into the criminal justice system? We don't have that data, and so we can't tell you how effective those systems are. We think that would be very helpful to all members in our community and to the law enforcement community, to all of our partners in the criminal justice system. I'll end with this. The bill refers to this data being reported to the Sentencing Guideline Commission. I believe Senate research, we could refer to Mr. Backus on this, but I believe part of this bill language came from, as County Attorney Freeman mentioned, 60911, which is the statute that regulates firearms. And in the firearm statute, 60911, they are required to report that data to the Sentencing Guideline Commission. The reason I tell you that is that the infrastructure is already there for the reporting. It doesn't, you don't have to create a new software system, or county attorneys would have to become familiar with different systems. This just expands the reporting to the Sentencing Guideline Commission on felonies, which, and as I mentioned, already is in place on 60911 charges. So with that, Mr. Chair, thank you for the opportunity to speak with you guys today, and as Chief Warner said, we'll stand for any questions you might have during the hearing.
Thank you, Mr. Potts. Next on my list, I have Attorney Freeman. Smalls? Mr. Smalls?
Just take your chair.
Okay. And if we could, keep the comments, tightened up here. We got another bill coming up. So
Right.
appreciate it.
Mr. Chair, members of the committee, Mr. Freeman needed to catch an airplane, and so I'm going to take over for him.
Please do. He's well represented.
Thank you very much. So I'm very confused about the testimony I just heard, and maybe I'm missing something. Did you call it the transparency in charging? Because your bill deals nothing about charging. Nothing about charging. It is about dismissals. What it says is, in each case where the defendant is charged with a felony and a county attorney who dismisses it has to make a report. So this has nothing to do, and I love the chief, I love Jeff Potts, but they're talking about charging stuff. And this bill deals with dismissals. So I don't know why this is called the transparency in charging when the bill is about dismissals. Now, it does say on the reporting is all crimes charged, but the focus of the bill is dismissals, all right? And so that's what I wanted to call to the committee's attention, and I'd stand for questions.
Mr. Chairman,
Senator Lance.
Mr.
Or
Chair.
Senator Limmer. Whoever would like to go.
Geez, Senator Lang gets called Senator Letts, and Limmer gets called Senator Letts.
It's a compliment, perhaps?
They're all gonna be pretty upset with me pretty soon here.
I don't
To
know.
tell
I
you
don't
the
know.
truth, Mr. Chairman,
Mr. Yu, yeah.
I don't know who's insulted more.
Can I just have a restart then on this? All right.
We don't have time in this hearing to go into that.
Mr. Chairman.
Senator Limmer.
In reference to Judge Short's comments, that might have been a little bit of my fault. We, as you can see in the description of the bill, there, on line 1.3, there's a reference to dismissing charges. On line 1.16, in each case where a defendant is charged, there's a reference. There's also on lines 1.21, all crimes charged. So there may be just a little bit of a reason for a little bit of confusion. And I thank Judge Short for pointing that out. Mr. Chair, in the interest of time, I'd like to have discussion, but we have a very important issue that people have traveled a long ways regarding the emergency bill that's listed on your agenda. But I would encourage, if anyone has any comments from the committee, if we can keep it very brief. These people have traveled a far way, and we want to respect that.
Senator Lance. Senator Lance.
Thank you, Mr. Chairman, and the author of the bill, Senator Letts.
Well, really knows how to hurt a guy.
As this committee knows, I generally favor transparency and data. I prefer to have data available for decision-making, policy-making here in this committee, which is another reason I'm a little bit confused, because this bill promotes the importance of data in making decisions. But we had a series of mandatory minimum sentencing bills come through this committee in which I asked each one of them, where's the data to support that these will actually improve public safety, reduce recidivism, help reduce crime? And I got nothing for an answer. I was told there isn't any data forthcoming as part of the advocates, but we should just use our common sense. And that was all I got. So if we're going to be in favor of evidence-based proven program, database decision-making. Let's apply it to all of the bills that come before here, rather than just saying, let's get tough on crime, let's get tough on the wayward prosecutors who are doing something in their communities, maybe even reflecting their own community's preferences that we don't agree with. Some of us here at the legislature don't agree with. On that note, if we really are in favor of local control, then we should let the local prosecutors who are accountable to their local taxpayers and their local voters reflect their local's community's priorities as they see it, and if their communities don't like it, they can vote them out of office the next time around. But I do have a question about the details of this bill, and that is just one question. It looks to me like on line 2.1, it's supposed to reflect whether, the report is supposed to include whether the victim supports the dismissal. We are going to know what case it is because on line 1.19, the name of the defendant is reported. So it will be a publicly reported defendant. I would note it does not seem to make any distinction between juvenile defendants and adult defendants. So I think there's a serious problem with that. But also, if you know who the defendant is, it won't be too hard to find out who the victim is in a particular case. And I'm not sure we want to mandate that the Sentencing Guidelines Commission have a comprehensive database of every victim of an accused felony case in Minnesota, especially ones that were dismissed, maybe because there wasn't enough evidence independent of the victim to be able to proceed. I'm not sure we want every victim to be held accountable for their opinion on whether a dismissal was appropriate. So if this bill moves forward, I would encourage us, I think, to delete line 2.1 from the bill. Thank you, Mr. Chairman.
Thank you, Senator Latz.
That's a good point, Senator Latz. Thank you for that catch. I have no further comments.
All right.
Mr. Chairman.
Seeing no further.
Mr.
One
Chair,
more? Oh,
really quick.
Senator Kiffmeyer.
I was just sitting here thinking, our police wear body cameras. You want to talk about documentation? Police wear body cameras. Talk about the epitome of documentation. And plus, they document everything. And they are hired to serve us. But here we have a situation of county attorneys who are elected. And the people need information as far as when they are making choices for their election. So I just thought it was an interesting thing where you have body cameras and now we're considering this is too much to ask. I just thought that was interesting.
Thank you, Senator Kiffmeyer. Could you imagine that hours of footage of a body camera of a prosecutor? Just paperwork after hour. Fascinating. Any further comment, question? All right. Thank you, Senator Limmer. We'll lay this bill over for possible inclusion.
Thank you.
We'll skip down to the fifth order of business here. Senate File 534, Senator Weber, Local Planning Preparedness Efforts, Emergency Management Readiness Grants Appropriation. When you're
Thank you, Mr.
prepared,
Chairman.
Senator Weber, begin.
Mr. Chairman, members, pleased to bring you Senate File 534. This deals with our emergency management positions in our counties. Quite frankly, more and more is required of them all the time, and yet today they operate under a series of grants from the federal government, many of which are probably going to be coming into question. And so there's serious lack of stable and sustainable funding for our counties. And so just to be very brief with the fact, as I've been up here, this is my 10th session, I think about the areas within the natural disasters that have happened within the state, numerous ice storms, floods, what have you, all put demands on our county emergency management people. And so this bill would provide $3 million in state funds to the 87 counties, 11 tribes, and 4 cities of the first class, divided equally. Certainly, the larger the community, the more resources they have had for emergency management. In many of our rural counties, many of our positions, emergency management directors, who they're required to have, are a part-time position. And so I have with me today two individuals, Association of Emergency Managers. First is Kyle Oldry from Rock County, and I would turn the testifiers table over to them.
All right, thank you very much, Senator Weber. Mr. Oldry, could you please state your name for the record and how far you had to drive to get here today?
Thank you, Mr. Chair. My name is Kyle Oldry, O-L-D-R-E. I'm the County Administrator and Emergency Management Director for Rock County. Laverne, actually, Senator Weber is my neighbor, so it's, I know, I feel the same way. It's about 3.5 hours to get here. I may have a few for you as well. Thank you, Senator. I certainly appreciate the committee's time today for hearing this bill. It's been a very high priority for the Association of Emergency Management for a number of years to stabilize funding. And give you the example in Rock County. Rock County's EM grant in 2010 was around $17,000, a little over. And in 2019, it actually declined, went down $200. And emergency management is the funding for that is a required match. So Rock County's emergency management budget then is $17,000 from the federal government as a pass-through through the state. Goes through the state Homeland Security, and then Rock County matches also with $17,000. What we're asking for is stabilized funding, as Senator Weber put it, to try to level that out and bring the third leg of the stool, if you will, to the table. Minnesota residents would receive standardized emergency management planning, preparedness, and those types of things statewide. All 87 counties are required by statute to provide emergency management, and this brings the funding to the table from the state. The local emergency managers, you know, we're responsible for townships, cities within our counties, as well as the county as a whole. And this funding would allow for again, the planning, preparedness, and mitigation. This legislation is supported by AMC, the Rural Minnesota Counties Caucus, and even MICA. So you've got big, little, all seeing the value in bringing that standardized emergency management funding to the table. So that's, I was told to keep it brief. I'm promising to do that. I would, do I ask for questions now?
Yeah, you can, or let's say we'd like the other testifier to speak first, maybe, and have questions.
Questions now, Mr. Chair, or would you like to hear?
I do have one. Senator Kiffmeyer?
Thank you, Mr. Chair. I think my question is, I think I've heard about this before, Senator Weber.
Yes.
And that they have to apply to get this grant. And so maybe this has already been covered, equal amounts. So I just want to be sure, because this was a question before, if somebody forgot to apply for the grant. You know, and so I just want to be sure. In your bill here, does that fix it so that they don't have to apply, that they just get it distributed to them? I mean, I hate for somebody to not get it just because they might have missed a deadline.
Senator Weber?
I'll turn that to Mr. Oldry.
Mr. Oldry?
Mr. Chair, Senator, we do have to ask. The bill does read that we do need to ask, but there's not an application process, is my understanding. So it is a request. I'm confident that all 87 and the 11 tribal nations, as well as the 4 cities of first class, will ask. But it's my understanding as well that we would need to ask for that funding.
Thank you, Mr. Oldry. Senator
Yeah,
Kiffmeyer?
my question is there any county that does not have an emergency management function or office or somebody who serves as that? Sometimes the title isn't emergency management. It might be something else in some of these real small counties. Is there any county that does not have this?
Mr. Oldry?
Mr. Chair, Senator, no, we're all required by statute to have emergency management directors. So all 87 counties have it, and all 87 counties currently receive emergency management planning money.
Well, Mr. Chair, I'm just kind of wondering, Senator Weber here, because by the time you go through the application process, somebody has to ask, file the paper, do the paperwork. I don't know if something can be streamlined in that way so they get it. I'm not sure if we want to require an application. I'm just checking on that.
Mr. Chair and Senator Kiffmeyer, I'm certainly fine with making this an automatic situation whereby those funds are dispersed to the counties and tribes and cities. Quite frankly, I think that makes some sense in order to do it that way. And we can work on the proper language as far as what that would need to, the amendment would need to look like.
Mr. Chair?
Thank you. Senator Kiffmeyer.
Yeah, I just think, if you're going to do a report, what did you do with it? How did you spend it? I think would be more valuable, in this situation of where it's going out. I just throw that out as a possibility for adjusting maybe.
I would agree with you.
Thank you, Senator Kiffmeyer. Senator Ingebrigtsen.
Thank you, Mr. Chair, and thank you to the testifier. I'm going to date myself a little bit here. I'm not as old as the senator next to you there, but I do remember back when counties were required and they all had full-time emergency management directors. My dad was a sheriff in Kitson County back in the 60s, and they had full-time emergency management directors back then. So I think just automatically getting the money would absolutely be the best way. Senator Kiffmeyer had talked about, and these jobs are a lot of requirements by the state of Minnesota on these jobs, a lot of paperwork, but if you have it ready to go, it's there. So thank you for bringing it forward, Senator Weber. Thank you.
Thank you, Senator Ingebrigtsen. Further comments from the committee? Okay, you do have one additional testifier, Senator Weber.
Yes.
Like to
Mr.
make some
Eric
quick
Waggy.
comments? Thank you. Yep, please proceed.
Mr. Chair, members of the committee, I didn't come very far this time. I'm the Hennepin County Emergency Management Director. My name is Eric Waggy. I'm also a member of the Association of Minnesota Emergency Managers, and that's whom I'm representing. I support this because it's good for all emergency managers in Minnesota, and we are essentially a collective. None of us have enough resources to do the things we need to do, and so we share resources, and it's very important that capability exists across the entire breadth of the state of Minnesota, and it's in all of our interests to make sure that emergency management as a profession is well-funded and well-resourced across all parts of Minnesota. Typically, the way we're funded currently right now is we get a lot of federal funding, and that's valuable, and we appreciate that. But emergency management is really a state function, and the Constitution provides that it is a state responsibility to provide for public safety, except for a narrow set of circumstances. And so when we get federal money, it comes with a lot of federal attachments and strings and federal and national priorities that may or may not reflect the local realities on the ground in all of our individual communities. And so state money would provide us the flexibility and the agility to do what meets the needs of our local communities. So we think it's especially important. We don't want the federal money to go away, but it's not reliable. It changes, the amounts change, the priorities change, and we think that a more stable perspective would come from the state and St. Paul toward all of the 87 counties, the tribes, and the cities of first class. And so that's why we think it's a great idea. If you have any questions, I'd be happy to answer them as well.
Thank you. Any questions? Seeing none, thank you, Senator Weber. Do you have any final comments?
Just simply, Mr. Chairman, members, that I think that this is probably a $3 million expenditure that will do so much more than some of our $3 million expenditures do. And I would encourage your consideration of this bill.
Thank you very much, Senator Weber. This bill will be laid over for possible inclusion. Thank you for your time. Seeing no further business before the committee, we are now adjourned.